Thank you very much, Dean. It's a great honor to be here together with our colleagues to represent the EU insofar, and we are only a small fraction of the 27 member states. And you have already heard, and that's absolutely true, everybody has got a little twist here and there, and that might be understandable. Well, indeed, the FTA, a new one of this kind, is a bit of a jigsaw. And always for those who will be the front runners, and I mean Koreans have been in many, many areas the front runners, not with the EU, it's always the same, but they push the EU to be in this very exciting new concept of FTA. And the new concept of the FTA is mainly also to grant the basis for an open room, trade room. And the second issue, and we should not understand, is also to diminish the administration level. And therefore, a lot of novelties, which we have already discussed and we will continue to discuss, is the question how to diminish, at the end of the day, the administration. And I think the basic issue, the basic verification issues as well, is the common trust in the exporters and importers in using the same set of rules, and also the common trust in the administration, both on the Korean side and the EU administration side, to verify, to test in a fair and open and non-discriminatory way. I think we should keep that into mind when we talk about the EU FTA approach and the new system. Well, I will not talk too much about the rule of origins, because we have already covered that to a great degree, and only a few words about the approved exporter system, because that's the heart, in the end of the day, what is to be taken into account when dealing with the EU. Keep into mind the approved exporter system is there to diminish the burden of load, to diminish the administration in the front run. But there's no free lunch in life. It means we have to fulfill the conditions in order to get to the status of the approved exporter system, both sides, on the EU side as well on the Korean side. Well, there's not to avoid that in the end of the day there might be conflicts. And the best question is how to avoid these conflicts, so how to invest in the process and such that you got a good outcome. And we will talk a bit about the national courts, and I give you a couple of examples how is it used in the German courts, in the counteraction also with the EU side. And last but not least, a bit the administrative system in Germany to understand the correlations in the German market. There's one issue also not to let out of share, is the issue that, of course, the FTA is opening a market between the two commercial rooms, EU and Korea, but both sides do not want to harm their industry by inflictions from outside trade, so outside these two rooms. So the whole background is, and I think the question everybody has to put in the front when exporting to the other room is, do we really have got goods here which are falling under the preferential system, which is the way to enhance the trade between the two commercial areas? And what is actually not falling in the preferential system, because that's also not favored by the FTA. Very easy principle to understand, because it's also a political agreement, and a political agreement has to take certain conditions into account. So all the discussion of the rules of origins is indeed, in the end of the day, the question how to protect also the industry of the two commercial rooms, means Korea on one side and EU on the other side. In the end, it means also to protect your own competition vis-à-vis competitors outside these two areas. Well, to achieve is, of course, the rules of origin. And we have got, therefore, the principle of territoriality. So the goods and later on service must come out of these two rooms. And that's the second part is an add-on for the easiness of the administration, it must be subject to direct transport. Ms. Hull has already explained to a great extent the issues. Probably have got some nuances later on, and one of the questions you raised already this morning, Mr. Kim, was also about this. So you have got the principle of territoriality, where are the goods coming from? On the other hand, to help the administration to support, to find out, you have got the second pillar of condition, the subject of direct transport. Also, that is very much to keep into mind when you talk about the issues coming out of the FTA. Well, we do not have to go too much into detail on the origins as such, because we have discussed it already, and I'm quite sure the majority of you are very much deep into the issues, how to define it. Giving you here on page number 7 a couple of examples what you have to fulfill in order to become a product coming out of Korea or on the EU on the other side. And also please keep this into mind. The FTA is very, very much in favor of both sides here. There are much harder rules in order to qualify for a product in other FTAs. So the FTA with Korea or EU FTA is very, very favorable to both sides in order what kind of standard has to be reached and what kind of quantity or participation in the product has to be reached by one or the other side. What is the issue with the coming back to the direct transport? The idea is, of course, that you have not a situation where a product is put on a market in free circulation before reaching the final destination. So you do not want to have a melting of products coming from different origins. Already there, Ms. So already explained the issue of consignment. So when you transport goods from the EU to Korea or the other way around via stations, there must one principle kept always in mind. It must be under the control of the customs. It should not get into free circulation. And that's in the end what you have to prove by setting the conditions for the direct transport issue. And I think this principle might also guide you when you have got an issue with the customs authorities, that you have got a documentation ready that the products you have transported for one side or the other have never even seen outside the free circulation, and which means you have to prove that it has been always been the customs bonding warehouses, or it has a certain categorization of numbering, for instance, where you can prove what kind of product has to go in and out of this kind of reloading, for instance. So there's still a lot of discussions because we have also got less paper burden, so to speak, but I mean the general principle, you have got the burden of proof at the end of the day to demonstrate that there was one direct transport in the means that there was no putting on the free circulation in the market this kind of products. And we have got also decisions on that we'll come later on to. Well, the approved exporter system. The approved exporter system is definitely there to mitigate the burden of administration. But I spoke at the beginning, the system is based on common trust. You can only have common trust when you have verified that certain rules are in place and certain rules are also taken into account. So therefore, in order to make this declaration in the end of the day, which you put on your bill, the authorities on both sides must find also the reasoning to give you this approved exporter status, which means in the end you need a proper bookkeeping, you need someone authorized in the company, at least someone, who takes care of the process of finding out where the origin coming from, who knows where the bookkeeping is, and that you have got a kind of systematic approach how to deal with customs issues, especially free trade agreements issues in the organization. This is your, where I say this from, your pillar of trust within the company and your outside window to the authorities, both internally here in Korea, but also outside to the EU. In investing in this kind of preparation, you have got a lot of risk management already done, and you have got reduced your administrative burden, especially then when you have got verification processes, because you might come up with a relatively efficient way to start this. And this is one of the reasons why the EU is also very much concerned that this kind of verification system doesn't find this kind of trust into the other side and is pushing on this so much. Well, you have got a couple of formal conditions to the origin of declaration validity process. And unfortunately, this kind of level of administration has to be taken very much and very serious into account. Because in the end of the day, also that makes a lot of sense to keep that in mind, you deal with the money of the states. And for the European Union, also that you should know, customs income is a direct source for the European Union itself and its institutions. It doesn't go normally to the member state, it goes to the EU. So the issue is that it is one of the source of revenues, and when you give away this kind of source of revenues, you want to get something feedback, and this feedback is, of course, the kind of less of administration. The origin of declaration can be made by two. It can be by the approved exporter, or, which is, I guess, only for a minimum of importers, when you have got projects whose value do not exceed 6,000 euros. We have already spoken about it. So the approved exporter, this is the one who is actually the in favor, or who is favored by the FTA of that. How to explain it? Again, the FTA wants to reduce, mitigates the burden of administration, and therefore both sides have agreed of a kind of modern system. Each side is modern its own kind of companies. So a Korean exporter can only be authorized within Korea. A German or a EU exporter can only be authorized in the EU or in Germany, where it has its seat. So it means that you normally have got your direct contract partner, the direct partner, sitting in your own country, and you have the opportunity to approach them in your own language and in your own administrative way. So therefore, this is a great differentiation to other FTAs, especially within the EU, because there's a novelty where you do not have this. So therefore, normally a kind of mitigation of administrative burden again. But, having said so, you need, of course, both sides need, of course, follow the rules which have been agreed in the FTA, so there is no kind of exemption rules specifically done on the national side. And that's also true for all the 27 member states within the EU, despite all the differences in their praxis. In the end of the day, the EU, as it decides about the general practice in all 27 member states. I think that's the hardest hurdle. What is the evidence and the proof of direct transport conditions? And what kind of formal structures you need to keep, what kind of documents you need to keep at hand? And we have got here specifically in the protocol to the agreement here in Article 13 the key criteria mentioned, which are a bit hazy. So either you have got one consignment, one direct transport going through from Korea directly to EU. I think there should be no problem, because normally you have got one bill of loading, no issue. But that's not the reality. I guess the major part goes either via Hong Kong or via Singapore, one way or the other. You end up in bonded warehouses where there have been a reloading, repackaging, where also other transports from China or from Japan or India coming together. So how to make sure that you have indeed a kind of one way or one single transport? We do not have a kind of single document for that. Probably we have to create something new, or we have to organize in discussion with the different customs authorities how it can be done. Basically, one thing should govern all the administrative rules. As I said before, it must be proven that a product which is going from one area to the other area did not go out on the market, was not put into circulation, and was kept under customs control. So the burden is here probably a bit on the side of, for instance, taking the Singaporean authorities or the Singaporean bandit warehouses or the Hong Kong ones, in order to declare, to have a system in place to make sure that you can retroactively see the way where the goods have coming, how the reloading has been done, and to declare in an open and non-discriminatory way how the product stayed into the warehouse. Because decisions within the, going back to the EU jurisprudence, this problem is not entirely new. It has been there already for quite some while, and even there are debating decisions of the European Court of Justice more than 25 years, where the court said the basic principles is that you have to demonstrate, and the burden of proof lies with the, of course, with the importer, to demonstrate that there was kind of no no leaving out of the bondage area. But I mean, you cannot request something more like that, and that should be also the guiding principle with regard to the consignments and the direct transport aspects. So the issue is to discuss together with your warehousing, your consignment management, how to can prove, how you can document, if you have got a reloading, that exactly that consignment has been reloaded in such and such way, and the products going to the EU or vice versa to Korea have been in a way processed that you can assure that this kind of products have never left the customs area, the bondage area. The other issue is, also mentioned before, your internal organization. And that is a big concern from the EU side, and a bit also the suspicion. And we heard, for instance, that especially the Middle European or Eastern European countries are quite concerned. And I can imagine the reason is that a lot of Korean companies are the direct competitors with producers in these countries. I mean, of course, the Eastern and Middle European countries, the majority are less than 10 years member of the European Union, and they do not want to see that their advantage to become a member of the EU is eaten up in the end of the day by opening the markets to others. Well, the first one would be Korea. So let's say the room of suspicion is much higher. And the only way you can mitigate this and to, in the end of the day, come to a kind of normal relationship is to follow the rules very, very meticulously on the approved export authorization status, which means mainly that you have got a good bookkeeping, that you have got documents in store in your due time, all the elements which were mentioned by Mr. King earlier before. That's also the way you can get and build up the trust within the European administration as well. In the end of the day, however, you might come across stubborn organizations. We already talked about 27 member states. Everybody has got its own administration side, also governed by the EU and governed and guided by the EU Commission. But in the end of the day, they are all human beings. So if you have got such an element, you might think about what you can do, how you can protect yourself, and how you can go forward. Well, there are two issues to consider. Is a kind of forum shopping. Forum shopping so far, and Arnold has declared that quite quickly, and I fully agree with him, a couple of countries might be easier to convince than others. couple of countries might be easier to open in the administration type within the EU to non-EU importers than others. Why is that? Because they might have an interest to have got an import center in their own country. They might have greater experience in handling FTAs. They might have a greater knowledge about rules of origin. So all these issues have to be taken into account, and might be also an interesting point when you start exporting to the EU, which country you use as a kind of entry. Of course, that's a bit strategically thinking. That's a bit kind of forum shopping, as I know it, as I said it. But in the end of the day, that might be one way of smoothen or facilitate your agreements, especially when you have got a better access to certain countries than to others. If that's not the case, and you have been not rewarded a preferential tariff system, what can you do? Well, it is a decision of a national body, the administration. So you can definitely go to court, or you can try to settle, as Arnaud said, is on the level of the EU by finding out or helping or receiving the helping hand of the EU Commission. If you go via the courts, then you must take into account how you can do that. There's one issue one should keep into mind, and this is what kind of outcome you can receive after verification. When you have built up the level of trust by an orderly bookkeeping, by a kind of documentation, by having someone responsible in an organization, most likely, and I would say that's 90% the case, you will get a preferential treatment granted. So your verification process will end very positively. Conflict settlement of opinions, when there is a kind of elementary question, how, for instance, to characterize, how, for instance, what is a value added to a product, you might indeed end up in a dispute settlement before the Customs Committee. And normally, such a dispute you cannot settle on your own. It's much better to let it settle by your government, the Korean government, and the EU administration, or vice versa, because these general things you can support, but you cannot really settle because you have to convince and sometimes also find the political arguments to convince that. It takes much more time and is much more difficult. If it's not a kind of political issue, it's not a kind of elementary decision to be made, well, and nevertheless the preferential treatment has been denied because the authorities were not accepting, for instance, your bookkeeping system, or let's say your internal verification system, then indeed there might be room to go to the national courts and bring forward your argumentation why the administration was wrong here. I would always regard this kind of going to court as the last instance. I think one definitely should try by a proper argumentation with the national authorities, and probably also the help of the government to rectify it. But keep in mind, the burden of proof is with you. You have to fulfill the criteria of the proof exporter system. If you haven't done that, then you have got difficulties. The initial investment might pay off very well, especially in such a case. Well, the question comes up then, should be there definitely a case where you cannot settle it amicable, what kind of ways you can use to seek judicial review. And there's one very interesting aspect, surprising aspect in the FTA, in the ratification protocol, and this is only on the EU side where you can find it, where it said that the FTA agreement shall not be construed as conferring rights or imposing obligations which can be directly invoked before union or member state courts and tribunals. Well, that's very legal language, but what it could mean, or should mean, obviously, that there will be no direct application of your rights out of the FTA in the argumentation in the national courts. And this is contradictory what has been decided many, many times before by the European courts in other FTAs or other similar agreements, where normally as soon as the contract, as soon as the agreement is ratified, it becomes part of the EU law, and when it becomes part of the EU law, then the implementation effects is the subsequent matter has got direct effect, as long as it's clearly stated. So this kind of Article 8 of the protocol is still under observation in order to discuss what actually the meaning of this by the EU. I do not believe that it can be really contrary to the oldest jurisprudence we had in the past, where the court really said that there must be a direct effect, so that you must directly rely on the conditions foreseen in the FTA. But it's too early to say. We don't have cases yet where this has been tested, but definitely keep that in mind when you consider to go to court. Well, let's have a word about the German system or the German administration system. Again, as Arno clearly said, we have got one set of rules, which are the rules, and Germany is also bound to it, but you have got the national administration side. And here, the issue is, as I said before, what the German authorizations, what the German administration is very much looking at, that you have got an accurate system internally set up for the verifying your origins, for keeping a good bookkeeping, for having got access to your files and to your documentation at hand. Should you be able to do so, I don't think that you might have any problems with that. Should you have got a lack of documentation, however, should you have a lack of responsible person in your organization, or if you have got a large organization, several persons, then you might get into difficulties also with the German authorities. So the best is to write a kind of instruction, external instruction, which you could demonstrate, which you can show in kind of a verification process, how you organize yourself and what are the steps, what are the quality management system steps you have got internally in order to prove that you have got the right system in place. Again, like in Korea, should you have falsifications, should you have wrong statements, should you have not followed the rule, you have got severe sanctions under the German fiscal code as well. So, and that's true also in other member states, as Arno rightly said. Different sanction systems per member state, but nevertheless, I mean, all go in the right direction, either fines or worse, criminal sanctions when, I mean, you go into the fraudulent area. So how to stand up these kind of working organizational instructions? I think these are absolutely key to have in order to go through a smooth verification process. You have to, step by step, to describe your conditions for the checking of the origins. You have to describe how you go forward with your transport system. You have to describe how you keep your documentation in place and things like that. And last but not least, who is the responsible person in your organization you can name, and who is the sparring partner, so to speak, with the customs authorities. And that's absolutely crucial. And I only can recommend everybody who is going to start, and that's not only with regard to Germany, start exporting to the EU, to do this kind of initial thinking and prepare yourself for that. Apart from that, and apart from some other minor issues, you do not really have to do a lot of further documentation with regards to the German practice. So you do not have to have any kind of declarations from the customs authorities themselves. You have to see the difference with a lot of other FTAs. You have a kind of quite detailed organization chart and authorization model with other authorities. With the FTA between Korea and the EU, you don't have this. Again, a kind of factor of mitigation of administrative burden to you. Transport documents, I think, are the most important ones with regards to the verification process when you think about the direct transport. Keep that in mind, and keep also some structure in mind when you have what we discussed before, this kind of reloading, repackaging in bondage houses in, for instance, in Singapore and Hong Kong or other places. So when there is a chance that there will be a mixture of different projects from different origins coming together, you have to make sure, and the burden of proof is with you, where the origins come from. Consequences, as I said, there's if you have fraudulent statements made, if your declaration is not correct, the German fiscal code foresees, well, imprisonment up to 5 years, and in serious cases up to 10 years. And even if you support someone, if you an importer, for instance, support someone to act fraudulently, you can fall under these sanctions. And if you make recklessly inaccurate declarations, you can up to fines of 50,000 euros. So these are, of course, maximum fines. There might be stages on this, but at least for the number of export-imports, it might be quite an important number to keep in mind. And especially also when there are false declarations made by German exporters, so it's vice versa. So if you see, for instance, that one of your competitors is not following the rules of the FTA, and the competitor from the EU, well, you can also insist not only on the verification process, but you can also insist that probably there will be fines or even further criminal sanctions being imposed if there is a kind of violation of the rules. And you can be sure that more and more, like in all the other areas of regulatory law, these rules are used as instruments in competition. So to disdain your competitor, you make clear that there have been violations, is a kind of hindrance and going forward, and a kind of competition tool to harm the other side. You will be harmed, and I think on the other side you have also to detect errances on your competition when there are violations of the rules. Well, if you know, the FTA is only 3/4 of a year in force, so it's very, very early time to see what are the consequences, what will be the further way going. I guess the main issue is we have to overcome, both sides, this kind of common mistrust at the beginning. And I'm pretty sure that with the lapse of another 2 years, the numbers we have seen up of verification processes will go down, simply for the fact that both sides have accepted rules, accepted places in form, and will trust much more than probably it used to be at the beginning. A big issue is, of course, very much a substantial issue is, of course, that the rule of origin is not violated. Especially that both sides are not concerned anymore that imports from third countries are used by the FTA to exporting the other commercial zone. Because that's a great fear, coming back to the point with a lot of Middle and Eastern European countries. So when they see that it is functioning and it's not being a kind of source for them of being concerned about their competitive situation. At the end of the day, I gave you two judgments. I mean, it would be now a bit too far-fetched to go here into detail, but you see that a lot of issues with regard especially to direct transport are not new terms. So a lot of solutions might be found even in the jurisdiction of the EU courts with more than 20 years of experience, and also on the national courts as well. And there's sometimes quite interesting cases. Well, there's an import from Bangladesh on the one hand side, and another situation where you have got imports from Cambodia. And in both cases, in the end of the day, the courts came to the basic principle: you must be able to demonstrate that you fall under the preferential rules, and that the transport aspect is only a kind of administration tool in order to check where the goods are coming from. But in principle, if you can prove that the origin stems from the origin you say so, there must be a way also to grant them the preferential status. But you need to keep a source line, and you need also to keep the burden in proof into mind. Thank you very much.